Many new entrepreneurs are eager to form their legal entity or to establish intellectual property. There's a right time and process for when to put these together, though. We'll be providing some general information and tips here, but for more company-specific information, it's important that you consult a lawyer. We'll cover 3 things today: your company entity formation, intellectual property, and some common pitfalls. When it comes to formalizing your company entity with the proper paperwork and approvals, it's often beneficial to wait to do this until you need this level of formality. There are 2 main situations that can force this need: getting investment in your company, which then requires you to create the formal rules of your operation, or when you're taking on a lot of risk, usually through having a lot of customers. Waiting until one of these drivers can be helpful, since it gives you more time to work on your business and with your team to be able to see what kind of formalities you want to have in your documentation, including things like the equity allocations. When deciding what type of entity to form, we recommend reading up on the different options and the nuances of each. The main differences include taxes, liabilities, and a few other logistics. A few of the options of legal entity types include sole proprietorships or partnerships. This is where the founders are entitled to the profits, but also responsible for risks. An LLC, or limited liability corporation. An LLC allows flexible management and tax structure while allowing you to separate your business liabilities from your personal assets. A corporation is a legal entity that's separate and distinct from its owners. It has the benefit of being recognized outside the United States and tends to be used for larger, scalable companies. There are 2 main types of corporations: a C designation or an S designation. A few key differences between the 2 are corporate income tax and limitations on the number and nationality of shareholders. The last type of entity we'll cover is a nonprofit. The most common type of nonprofit is a 501c3. This provides tax breaks, limits your liability, and makes the entity eligible for grants and donations. You should keep in mind that being a nonprofit is not the only way that your company can have a social mission, and nonprofits can generate revenue. In fact, many do, to be able to have a more predictable source of their funds. The next legal consideration that we'll cover is intellectual property, or IP. These may include trademarks, copyrights, and patents, among many others. An example of a trademark is a company name and logo. A trademark is legally registered to protect against other individuals using your name or brand identity without your permission. Copyright is the exclusive legal right to an original literary, artistic, software, or musical material to its originator. Registration with the U.S. Copyright Office isn't necessary to secure copyright protection, but it does provide a public record of the copyright claim. A patent is a right granted to an inventor by the federal government that permits the inventor to exclude others from making, selling, or using the invention for a period of time. The patent system is designed to encourage inventions that are unique and useful to society. For an invention to qualify for a patent, it must be both novel and non-obvious. While copyright is granted automatically, a patent must be applied for by the inventor through the U.S. Patent and Trademark Office. The inventor must apply within 1 year of publicly disclosing the invention, such as through publishing a description or offering it for sale. You can make a search of patents on the USPTO website to see what ones already exist and to know better whether or not it's feasible for you to apply. Remember when discussing IP to use the correct terminology. Trademark protects your naming or branding. Copyright protects tangible creative material. And a patent protects a novel and non-obvious invention. Intelligently determine which forms of IP you'll need and when you'll need to have it registered. Don't just think about how to protect your own IP, but remember not to accidentally steal other people's. You can search for all trademarks and patents on the USPTO website. Finally, we'll cover some of the most common legal pitfalls. One of the most common is to accidentally use the intellectual property of others through taking images randomly from the internet. Copyright exists on almost all images, unless you use something like Creative Commons. Additionally, you should try to choose a strong company name that you would have the opportunity to trademark. This is in addition to just getting a domain name. You should look on the USPTO website to see what names are already trademarked. And if your name is too generic or descriptive or sounds like a similar company, it may not be able to be trademarked. Remember, while this information should give you a good start, for more specifics on your company, consult a lawyer.